Good afternoon, ladies and gentlemen. May I have your attention, please? Our session is about to begin in several minutes later. Please have a nice seat. Assalamualaikum warahmatullahi wabarakatuh. May peace be upon us all. Good afternoon, ladies and gentlemen, distinguished speakers, chairs, respondents, and all participants who have been joining in the online Zoom meeting. Welcome to the 5th Indonesian Constitutional Court International Symposium, Iccis. Before we start our first session today, let's hear a brief opening from the head of Center for Research and Case Analysis and Library Management, the Constitutional Court of the Republic of Indonesia, the Honorable Mrs. Kurniasih Pantirahayu, and the Editor-in-Chief of Constitutional Review Journal, Pan Muhammad Faiz, PhD. Mrs. Kurniasih Pantirahayu and Pan Muhammad Faiz, PhD, the time is yours.
Honorable Justice of the Constitutional Court of the Republic of Indonesia, Dr. Suhartoyo, Honorable Justice of the Constitutional Court of the Republic of Indonesia, Professor Dr. Saldi Isra, Speaker, Chairs, Respondent, and online participant. Assalamualaikum warahmatullahi wabarakatuh. Good afternoon from Bali, Indonesia. Thank you to each and every one of you for being here with us today. We are very pleased to be able to welcome those of you that have been with us for a long time now, as well as those who are new to Indonesia Constitutional Court International Symposium ICCIS. Today mark our 5th annual Symposium of the Constitutional Court of the Republic of Indonesia, following the success of our previous international symposia in Surakarta in 2017, Yogyakarta in 2018, and Bali in 2019, and Bandung in 2021. We are proud to be able to host it today here at this wonderful place with all of you. Before we get started, I would like to express my sincere appreciation to all of you who generously help us make this event come together to become a success. Organizer of Center of Research and Case Analysis and Library Management of the Constitutional Court, Center for Research and Case Analysis and Library Management of the Constitutional Court of the Republic of Indonesia, Center of Communication Technology. We couldn't have done it without you. Due to the COVID-19 pandemic, the 5th ICCIS will be held both online and in person at the venue. The ICCIS is an annual global academic for legal scholarship which discusses ideas and insights from law professors, legal scholars, judges, and practitioners. This year's focus on issues concerning constitutional court and conflict resolution. Selected articles from the 5th ICCIS will be published by the Constitutional Court Academic Journal, Constitutional Review, managed by our Center for Research and Case Analysis and Library Management. During the next 2 days, we expected to generate many ideas from the different perspectives of constitutional and comparative law, as well as to offer new perspectives on development in subjects related to the symposium theme. Well, I don't want to take too much of your time. I need to leave some time for Pan Muhammad Faiz, PhD, to introduce himself to all of you and fill of you on some of our upcoming sessions. So, a very warm welcome to each and every one of you. If you have a question, suggestion, or clarification, you can find organizer in this room. Now, without further ado, I invite Pan Muhammad Faiz, Editor-in-Chief of Constitutional Review, to deliver a brief description of today's event. Wassalamualaikum warahmatullahi wabarakatuh.
Thank you, Ms. Ayu. Good afternoon, everyone. May peace and prosperity be upon us all. Distinguished speaker, chairs, respondent, on behalf of the committee of the ICCIS and Constitutional Court of the Republic of Indonesia, we would like to warmly welcome you all at the 5th Indonesian Constitutional Court International Symposium. It is a great honor for us to invite you as an expert, a prominent scholars in this event. Please allow me to convey a brief explanation because this is just pre-opening. We haven't started the official opening by Justice Saldi Isra. So we will have the same perspective on what will happen in this symposium. First, about the ICCIS. The Indonesian Constitutional Court International Symposium is an annual event as an academic forum for scholars from various countries with themes related with the Constitutional Court and some other like constitutional law issues. And I see that some speakers here have attended this event previously. We have Justice Engin Yildirim, we have Dr. Rosa, we have Dr. Andi Omara and Dr. Yance, because it is the 5th event of International Symposium. And most of you probably it's the first time to join this event. So this year, the International Symposium is one of series of a major international event of the World Conference on Constitutional Justice, WCCJ, which is also attended by judges from various countries. So you will not only meet some other scholars, but you will also meet judges. Also in this room, we have Professor Bertus, a member of State Tribunal Administration from Western Australia, from Perth. So it is also to know each other and to broaden our network. In this symposium, we have chosen and invited you to convey your ideas and thought, both in written and also in oral forms, as well as to actively discuss each other. Therefore, let us use this limited time for 2 days by having fruitful discussion please do not leave the symposium without prior notice. This have to be underlined. Right, Dr. Rosa? Okay, first about presentation mechanisms. As we have explained in the guidebook, each sessions of the symposium will be guided by chairs. We have 4 distinguished chairs who have in their positions, and the chairs will invite the speakers and respondents to sit together in the front. So this is for the chairs and then for the speakers, and 2 respondents will be sit next to them. So it's different with the previous one. Usually they just give a comment from their chair and from table, but this one, more fruitful discussions, and Dr. Andi Omara. And the speakers will deliver presentations of no more than 20 minutes because we only have limited time. And there will be a timer set up on the TV screen, just to remind you, because sometimes when we speak, sometimes we forget how long we have present our ideas. Then after the speakers delivers the presentations, each respondent will be given an opportunity to provide comments or even criticisms or questions. The maximum time allocated for each respondent, because each speaker have 2 respondents, so please be wise, use within 3 to 5 minutes to give comments. So why we set up like this? Because we want the respondent learn first about the paper and then give a comment. So it will be a deep discussions. For your additional information, this symposium is also followed by online participation via Zoom meeting. And participants who register via Zoom has reached more than 1,000 people. But we only have limited space, so we invite of them, but no worries, they still can follow the symposium using YouTube live streaming of Constitutional Court. And it will be recorded, but you don't have to worry that then you will be very careful in speaking now. This is an academic forum. And it can be play later, repeated anytime, every time by probably your students as well. So the 4th things that I would like to share is about Constitutional Review Journal. Some of us here are the reviewers of the journal and also have been submitted an articles. The article that you submitted and will be discussed in the symposium has a potential to be published in the Constitutional Review Journal, a journal published by the Constitutional Court of Indonesia that has been indexed by Scopus and has an international reputation among the Constitutional Court worldwide. So the article could be reference for the judges, not only in Indonesia, because we send the journal to other constitutional court and also to library. Some reputable university, they have subscribed online, so it will go to their database. It will be easy find, and probably you will get more citations on your articles. However, your article will be reviewed one more time, so the last round, using a blind review just to ensure that your article has high quality analysis according to the standard that we provide in Constitutional Review Journal. So it is a mix that you present your paper, then you will get feedback, comment, suggestion, then you improve the article, then the last stage, it will be reviewed externally by anonymously. And there are also speakers in that field. So last thing that I would like to know, there is a saying in Indonesian, Dr. N. Black, tak kenal maka tak sayang. If we translate literally means, you cannot love what you don't know. In other words, out of sight, out of mind. So before we start opening the symposium by Justice Suhartoyo and Justice Saldi Isra, I think it's a good idea to get to know each other. I will give opportunity for all the speakers to introduce themselves, but no more than 30 seconds. Please introduce your name, university affiliations, and your research interests. And we will start using clockwise direction. Probably start with Professor Bayu Dwi Anggono, and then start then until Max, and then end with Rosa Ristawati. Please.
Thank you, Vice. The honorable speaker and attendant of this conference. It is such an honor for us to be here among reputable scholars in this very beautiful island, Bali. My name is Bayu Dwi Anggono, and I'm here with co-author this paper, Rian and Nandu. I'm from Faculty of Law, University of Jember, and my research interest in constitutional law. Thank you, Vice.
Thank you. One thing that he hasn't mentioned, Professor Bayu is a dean of law school from University of Jember.
Greetings, my name is Roy Partain. I'm with the University of Aberdeen in Scotland. I'm a professor of two subjects for our university, and one of them is comparative and international law, and the other is mathematical structures in law. And that's because I was originally a professor of economics before I became a professor of law. So I'm always looking for deeper symbolic or actual structures in legal logic and legal understanding. So I hope I will be able to help from that perspective. Thank you.
Cool.
Greetings, everyone, and delighted to be here with you in Bali. So glad I'm not doing it by Zoom. And I'm an associate professor at the University of Queensland in Australia. And my area is essentially comparative law, especially the law of Asia. So I try to put an outsider's perspective on law and try and understand its coherence as an outsider. So I teach courses on Asian legal systems and on Islamic law. And I was one of Faiz's supervisors, so I know what a difficult person he can be. Happy to be here, thank you.
Thank you, Faiz, for the invitation, the excellent arrangements. My name is Bertus de Villiers. I am by accent South African, but I live in Australia where I am a member of the judiciary, and I'm also a professor at Curtin University in Perth and the University of Johannesburg in South Africa. My area of specialisation is comparative constitutional law, and it's a great honour to be here just to listen to what we've heard so far. Thank you.
Good afternoon, everybody. My name is Michael Vallas. I'm a senior lecturer of law with the Hague University of Applied Sciences in The Hague. I'm very happy to be here with all of you. Thank you very much for the kind invitation. Many thanks to the organizers for all their help, including picking me up from the airport and bringing me to my hotel, which I really appreciate after 22 hours of flying. My field of expertise is public international law and international criminal law. Today I will be discussing a little bit questions pertaining to amnesties. Thank you very much.
Hello, everyone. It's an honor to be here. Thank you very much for the invitation. My name is Miriam Cohen. I'm a law professor from the University of Montreal. I'm a Canada Research Chair on Human Rights and International Justice. My areas of expertise are international law and human rights. and we'll be talking about the evolving role of the Supreme Court of Canada in conflict resolution in human rights cases. Thank you, everyone. I'm joined by my co-author, Sarah Michelle Vincent-Wright.
Hi, everyone. I'm very happy to be here with you, and thank you for the invitation. I'm a PhD student in law, and I'm here with Ms. Cohen for talking about international law, and thank you very much.
Good afternoon, everyone. My name is Yance Arizona. I'm from Department of Constitutional Law, Faculty of Law, Universitas Gadjah Mada in Yogyakarta. My research interests on constitutional law, forest and land conflict, and also indigenous people's rights. Thank you.
We should continue with Max.
Good afternoon, everyone. Thank you so much, Faiz, Elma, Rosmalina, all the organizers. It's a privilege to be here. I'm assistant professor at the OP Jindal Global University in India and assistant professor of political science at the Communist University in Slovakia. My research interests are primarily around democracy protection in the European Union, in Central Europe, and also constitutional courts and their understandings of democracy. So I very much look forward to this exchange of ideas. Thank you.
Hello, good afternoon, everyone, and thank you for the organizers for this excellent arrangement. It's an honor to be here. My name is Mofa from Universitas Ibnu Khaldun in Bogor. My primary expertise is water law and chemicals regulation, and I will talk about the Constitutional Court decision regarding the water law judicial review. Thank you.
Good afternoon, dear colleagues. I'm also privileged to be here today. My name is Szabó Zsolt. I come from Hungary, and I spent a day in Jakarta before coming here talking to some people who were not really aware of Hungary, and they asked whether or not I came here for the G20 preparations. And I said it would be excellent if my country would be part of that. I am an associate professor of constitutional law in Hungary. I'm working for the Protestant University of Budapest, Károly Gáspár, and I hold also a research position in the University of Public Service in Hungary. But before switching to academia, I was working also for the legal service of the Hungarian parliament. And this is why my main focus is on parliamentary procedure, and especially now I'm looking at the parliamentary and judiciary relations, how the judiciary can be involved in problems of parliamentary procedure and can control parliamentary procedure. Thank you very much.
Good afternoon. I also would like to express my great thanks for the invitation to come here. It's a real honor to be in this group with everyone. I'm Christie Warren. I teach at William and Mary Law School in Virginia. We're the oldest law school in the United States. My fields of teaching, research, and publications are comparative law, comparative constitutional law, Islamic law, and post-conflict justice and the rule of law. I direct also the law school's Center for Comparative Legal Studies and Post-Conflict Peace Building, and my field work for the last decade and a half has been on post-conflict and post-conflict constitutions, and that's in part what I will be talking about tomorrow. Thank you very much.
Good afternoon, everyone. My name is Engin Yıldırım. I work as a justice in the Turkish Constitutional Court for more than 12 years. Before being appointed to the court, I was a professor of labor relations at a Turkish university. Whenever I find a spare time, I try to write academic papers, especially in the field of labor law, collective labor rights, and LGBT rights. Thank you. And I also take this opportunity to thank Mahkeme-i Konstitü for their warm hospitality and generosity. Thank you.
Hello, everyone. My name is Andi Omara. I am an associate professor in Constitutional Law Department I am a lecturer of constitutional law in University of Gadjah Mada School of Law, and my major is actually concerning about the protections of human rights, and we are looking at the constitutional court decisions. But for this particular event, I will look at how actually the constitutional court resolve problem concerning the Truth and Reconciliation Commission's law. Thank you.
Good afternoon. My name is Uyong Ri. I'm from South Korea. Uyong is my first name. Ri is my last name. I'm currently a member of the faculty of Seoul National University School of Law in Seoul, South Korea. Before I joined the faculty in 2004, I worked for about 3 years in the state of California as an attorney in the United States. And I've been teaching and doing research at Seoul National University since 2004. Teaching undergraduate and law school and also graduate doctoral classes in general subjects of constitutional law and public law in general. And then I specifically interested in system design for prosecutorial reform in South Korea and also the legislative process and the statutory interpretation as well. I appreciate this opportunity to be part of this wonderful conference and nice meeting you all. And I look forward to inviting you here all to Korea one day for a conference. Thank you so much.
Good afternoon, everyone. It is an honor for me. My name is Rosa Ristawati, and I'm a lecturer at University of Erlangen. And my research area is on constitutional law and comparative constitutional law. It is very nice to meet all of you. Thank you.
You don't want to introduce your co-authors?
He can introduce himself.
All right. Thank you, everyone. Finally, we hope that our hospitality that we provide from your arrival at the airport until at the end of this event can well be received by all of you. If you have any questions regarding the symposium or other additional or related activities, please do not hesitate to contact the committee. And if you want to discuss further about the Indonesian Constitutional Court, Indonesian law in general, or you have a similar research interest, then probably you can have a further discussion each other. So without further ado, then I will return to the MC and we will have an official opening ceremony by Justice of Indonesian Constitutional Court. Thank you. Wassalamualaikum warahmatullahi wabarakatuh.
Thank you so much, Mrs. Kurniasi Pantirahayu and Pan Muhammad Faiz, PhD. Ladies and gentlemen, we cordially welcome the Honorable Justice of the Constitutional Court of the Republic of Indonesia, His Excellency Professor Saldi Isra, and His Excellency Dr. Suhartoyo. Ladies and gentlemen, we will hear the official opening remarks that will be delivered by His Excellency Dr. Suhartoyo. Dr. Suhartoyo, the time is yours.
Thank you. Assalamualaikum warahmatullahi wabarakatuh. Selamat siang, good afternoon. His Excellency Justice of the Constitutional Court, Professor Saldi Isra, the Honorable Secretary General, tidak ada ya, of the Constitutional Court, Professor M. Guntur Hamzah, the Honorable Head of Center for Research and Case Analysis Library Management, Ms. Kurniasih Pantirahayu, distinguished speakers, chairs, respondents, committee, and participants, ladies and gentlemen. I feel honored to be part of this symposium, the 5th Indonesian Constitutional Court International Symposium, ICCIs. I would like to welcome all symposium participants to Bali, that is known as the land of God or the island of paradise. Distinguished ladies and gentlemen, today's symposium is the 5th international conference held by the Indonesian Constitutional Court as an expert meeting amongst academicians, practitioners, legal researchers, and experts to discuss constitutional issues and exchange ideas on best practices for the role of the Constitutional Court of equivalent institution in realizing the fulfillment of constitutional rights in its state. The 5th ICCS is a series of activities of the 5th World Congress of Constitutional Justice. The 5th WCCJ is a regular worldwide meeting of constitutional judges to discuss issues of exercise of the authority of constitutional courts and equivalent institutions in various countries from a variety of perspectives. The 5th WCCJ theme is constitutional justice and peace. Meanwhile, the theme of today's symposium is constitutional court and conflict resolution, which consists of 5 sub-themes. They are: first, constitutional interpretation relating to peace and reconciliation; second, the role of constitutional court in adjudicating cases relating to social and political conflicts; third, the protection of human rights and democracy by the constitutional courts to settle conflicts; and fourth, constitutional court and mediators and armed conflict and civil military relations. Ladies and gentlemen, after rigorous selection process with high standards, we invite speakers with backgrounds from experts, academic practitioners, and legal researchers who are representatives of 10 countries, namely in the United States, Australia, the Netherlands, and South Korea, Scotland, Canada, Hungary, India, Turkey, and Indonesia. All speakers will convey their ideas and thoughts related to the theme of the symposium, as well as how best practices are implementing the authority of the Constitutional Court and equivalent institution in each country, so that this academic meeting can reflect perspectives, experience from different parts of the world. The 5th Indonesian Constitutional Court International Symposium will last for 2 days, from the 5th to the 6th, will be divided into 6 sessions, where each discussion session will be guided by chairs who are legal experts in Indonesia, including former constitutional judge, the Honorable Dr. Idewa Gede Palguna. Ladies and gentlemen, I hope that the discussion in the 5th ICCI's Indonesian Constitutional Court International Symposium can take place well, and the results of the discussion can at least help each participant to understand issues relevant to the theme, useful and experience on brainstorming, and experience and building effective effort to solve problems related to the role and implementation of the authority of the Constitutional Court and conflict resolution in community. The series of fifth ICCS activities will end with the culture program as medium for stress relief and healing to enjoy the panorama and natural beauty of Bali, Indonesia. After 2 full days of serious discussions, it coming to the end of my welcome remarks that I can convey, hopefully, the good relationship between the Constitutional Court and academics and legal experts from various foreign countries and always be well established. Thank you very much for your kind attention. Wassalamualaikum warahmatullahi wabarakatuh.
Thank you so much, His Excellency Dr. Suhartoyo, for the welcoming remarks. Ladies and gentlemen, now let's hear the keynote speech that will be delivered by the Honorable Justice of the Constitutional Court of the Republic of Indonesia, His Excellency Professor Saldi Isra. Please welcome Professor Saldi Isra to deliver the keynote speech.
Thank you all. Assalamualaikum warahmatullahi wabarakatuh. Good afternoon. Greeting to all of you here today. Frankly speaking, it will be quite heavy for me if all participants allow me to deliver my keynote in Bahasa. But unfortunately, Faiz pushed me to deliver this speech in English. That's why I have no choice, then I have to deliver this speech in English. I'm so sorry for all participants. Maybe for my poor English. Dr. Suhartoyo, my Honorable College Justice of the Constitutional Court of the Republic of Indonesia, Your Honor, Professor Engin Yildirim, Justice and Vice President of the Constitutional Court of Turkey. Not Turkey anymore, Turkey. Is it correct, Prof. Engin?
Turkey.
Who has been active and involved in every Indonesian Constitutional Court International Symposium. My friend, Professor Bertus from Australia, just left this meeting because he has another agenda in different rooms to deliver his speech in the short course. It is the dual functions of the source person in this meeting. Bertus, member of the State Administrative Tribunal of Western Australia and also professor at Curtin University in Perth. Together, we have been involved in several constitutional dialogues. I still remember 1 month before I became a judge in the Constitutional Court, we arranged a very huge constitutional dialogue in Perth. It is like the first step to create this program in the Constitutional Court. Then last year, we published a book together, then already published by Brill in Netherlands, Michael. Then we hope next year will be the 20th year of the Constitutional Court. We will publish at least 1 book in English that talking about the development of the Constitutional Court of the Republic of Indonesia. We hope some of the speakers will be involved in the next agenda, Faiz. It is order from the justice to the chief of this agenda. Professor Christie from William and Mary Law School, who has often sent students from United States to the court for internship program. This year already the 5th year, and next year will be the 6th years for this program. Michael Fagias from the Hague University of Applied Science. It is a pleasure to meet again. Then I hope you will invite me to The Hague again. Then we will arrange the special lunch in the Indonesian restaurant in The Hague. We call the Puncak restaurant there. That according to Michel, it is one of the very expensive restaurant in The Hague. Professor Roy, we talked a little bit about the Scotland. I was visit Scotland around 15 years ago. Then Professor Ray from Korea will come to Bali, but unfortunately you have very limited time in Bali. Then I hope Chakim, ex your supervisor, will invite you again to Bali next year. I hope so. And also Associate Professor Ann Black, the ex-vice professor. It is like what we call the collusion between the committee with the some of resource persons. Because there are special connection with the some speakers in this meeting. But it is normal, the way to find the good speakers in the forum like this. All three of whom I had been supervisor and lecturers of the Indonesian Constitutional Court employees while studying abroad. For example, Associate Professor Ann Black, the ex of Far East supervisors. Far East is one of my expert assistant. It is the new, what we call, the new name. The new name of the assistant before we call the researchers. Then we changed to the very prestigious name, become the expert assistant to the justice. Whether it is there are implications to the budget or not, I don't know. It is not the what we call the. It is not my job. It is the job of the Secretary General of the Constitutional Court. The chairs and speakers, whom I cannot mention one by one, but most of the Indonesian speakers, like Professor Andi Omara, Rosa Ristawanti, and also Professor Bayu, it is the fresh from the oven. He just decided as a professor a few months ago. Bayu, Dean of Law School of Jember University, and also in the end, Yance Arizona, also fresh from the oven, just finished his PhD from the Leiden University. Junior, I was one of his external examiner at the time. And also, ladies and gentlemen, in this room, first of all, I welcome the holding of this international symposium hosted annually by Constitutional Court of the Republic of Indonesia. This year's event is held simultaneously with the 5th Congress of the WCCG, the largest meeting and forum for the constitutional justices from 119 countries around the world. According to information I received from the committee, more than 90 countries are attending this Congress in person in Bali, while other countries are attending online via Zoom. Although this international symposium is one of the side events of the World Conference, because there are two different agenda. It is an expert meeting in another room, like short course, and also the joint meeting between the Secretary General of Ministry or Department to prepare for the next very huge meeting here for G20 agenda in this forum. Ladies and gentlemen, the theme of this year's International Symposium is Constitutional Court and Conflict Resolutions. Through intensive discussion, this activity aims to explore more deeply the role of the constitutional courts or similar judicial institutions in resolving various conflicts in different countries. We already discussed this topic far before the Ukrainian war. It is that nothing happened with the Russian wars. We already discussed this topic, Mikhail. The role of a constitutional court can be linked to its authority in interpreting the Constitution in order to contribute to peace and reconciliation. In addition, we can also examine the influence of the Constitutional Court in resolving social and political conflicts in its country. Another matter that also merits serious attention at this international symposium is the extent to which the Constitutional Court can provide protection for human rights and democracy, especially in safeguarding the principles of free and fair elections. More specifically, especially considering the current international situation, whether the Constitutional Court can act as a mediator in resolving armed conflict and conflicts between civilians and the military. Let me take this opportunity to explain the role of the Indonesian Constitutional Court in resolving various conflicts. Indonesian Constitutional Court has 5 constitutional powers. First, to examine the constitutionality of laws. Second, to decide on dispute over authority between state institutions. Third, to decide on the dissolution of the political parties. Fourth, to decide on the dispute over the results of elections. And fifth, or the last, impeachment of the president and or vice president. It is the last authority of the Indonesian Constitutional Court is quite different with the US model. In US model, the impeachment not only for the president and vice president, but also for many what we call high ranking of the officials. Through these authorities, specifically the authorities to examine through the vote to decide on dispute over the result of elections, the Constitutional Court has succeeded in resolving significant or potential conflicts. For example, in 2009, a few days before the presidential election, the Constitutional Court managed to ensure the 2009 presidential election went ahead. At the time, 2 of the 3 pairs of the presidential candidates intended to withdraw from the elections because they claiming that many of their supporters were unable to exercise their voting rights because were not registered. In this case, the Constitutional Court emphasized that the right to vote should not be hampered by the procedural issues that were not mistake of voters. Therefore, the Constitutional Court provided an opportunity for unregistered voters to exercise their voting rights in presidential election if they could show their identity card or passport. We have a law on election that specifically talking about if you are to use your rights to vote, you have to register in the special register paper. If your name there is no your name there, it is you lose your rights to vote. That's why at the time Constitutional Court decided that the procedural issues that were not the mistake of voters. Therefore, the Constitutional Court provides an opportunity for unregistered voters to exercise their voting rights in presidential election if they could show their identity card or passport. They could then use their voting rights at the domicile or location listed on their identity card. This decision ultimately became the best solution for preventing a potential national constitutional conflict at the time. Next example. In 2016, in a review of the law on population administration, the Constitutional Court succeeded in resolving a protracted social problem, a potential conflict experienced by followers of traditional beliefs in Indonesia. Indigenous belief or local faith are followed by millions of Indonesians outside the major religions recognized by state. However, these beliefs are not recognized or accommodated in the government's population administration. This means that followers of indigenous beliefs experience discrimination and were denied basic rights in various fields of life, including education, health, banking, and employment opportunities. In fact, it was not uncommon for followers of indigenous belief to be intimidated and bullied by other communities groups with different views. To end this social problem and potential conflict, the Constitutional Court decided that the status of followers of indigenous belief should also be included on their identity card and family card, so that their rights can be restored and fulfilled. This was a landmark decision that confirmed that guarantee for the constitutional rights of the citizen as stated in the Indonesian Constitution, 1945 Constitution. Ladies and gentlemen and all participants, the role of the Indonesian Constitutional Court in resolving political conflict stemming from dispute over election result is quite significant. As is the nature of politics and power, many parties use various means to gain seats of power, both at the national and local levels. In fact, it is not uncommon for clashes and conflicts to occur between supporters of rival parties and candidates. Such political conflict can subside when the election disputes are brought before the resolve by the Constitutional Court. Of course, there are prerequisites so that a decision of the Constitutional Court that resolves an election dispute can be accepted by all litigants. The Constitutional Court must have legitimacy, credibility, and public trust. Moreover, the process of examining these political cases must be carried out transparently and accountable, and the decision must have adequate legal reasoning. Thus, the feeling of the political disappointment and frustration from the candidate who lost in the election will be channeled properly through a trusted trial process, rather than leading to conflict on the streets by mobilizing mass groups of supporters. We have a very quite funny experience to resolve the result of the local election last year, Faiz. Why? Because one of the candidates already win as the candidate in the local election. The problem is the candidate kept two passports, as Indonesian and also the US passport, Prof. Christie. Then some of the local people disagree with this fact that they come to the Constitutional Court. And then in the end, we reject and abolish the result of the local election. To the date, the Indonesian Constitutional Court has decided 1,812 cases dispute over the result of presidential, legislative, and regional head election. If I compare to many countries like US, for example, here we have the very rigid process to overcome the dispute of the elections. Then I still remember last month when one of the professor from US visit Constitutional Court, Tom Ginsburg, Christie, I talked to him, hi, it's time for you to learn a little bit about the Indonesian legal system, at least how to overcome the election dispute. Because there is no, what we call the very standard model to overcome the election dispute in US until now. Is it Christie? For example, in 2019, Indonesian presidential election resulted in polarization of society. It is also happened in US. Two opposing camps attack each other and through accusations, resulting in division among the Nation people. In the end, this presidential election led to lawsuit at the Constitutional Court. With a transparent, accountable, and marathon case examination process, the Constitutional Court succeeded in resolving the dispute over the presidential election result in less than 14 days. Less than 14 days. The decision of the Constitutional Court, which consists of 1,944 pages. 1,944 pages. We already in marathon process. No more than 14 days. Was relatively acceptable to the parties. It became a momentum for political and social reconciliation, not only for the rival presidential election candidates, but also for the people who were divided because of their political choices. It is one of the good examples for us to discuss the role of the Constitutional Court to reconcile the society after the political momentum like what happened in 2019 in Indonesia. Furthermore, in the context of regional head election, the Constitutional Court can augment legal breakthrough by prioritizing the fulfillment of the substantive justice and not merely to fulfillment of the procedural justice. Not all violations that occur in regional head elections can lead to the cancellation of the result. Generally, the Constitutional Court can annul the election result if there are structured, systematic, and massive violations. Even if an election violation is proven, the Constitutional Court will not automatically make a petitioner the winner. In the interest of the wider public and with full prudence, the court will order to recount. To record of votes or re-elections to be held in relevant location. With the existence of an independent judiciary that is capable of resolving electoral disputes, political conflicts can be resolved or at least better prevented. In this context, the Constitutional Court, particularly in Indonesia, plays an important and strategic role in order to keep the consolidation of democracy progressing well. Ladies and gentlemen, based on the experience of the Indonesian Constitutional Court in resolving or preventing conflict, this international symposium is held as an academic discussion forum to discuss various dynamics of the judiciary in resolving various conflicts, not only in Indonesia, but also in various countries around the world. We will all hear interesting discussion and experiences from the experts present in this symposium. For example, Justice Yildirim will discuss the role of the Turkish Constitutional Court in the state of emergency of 2016 to 2018. Professor Ray will describe the experience of the Korean Constitutional Court in protecting fundamental rights through the mechanism of constitutional complaint. Professor Bertus will look at how to deal with a conflict of values between freedom of expression and hate speech. Then, Associate Professor Anne Black will have a proposal for the establishment of Constitutional Court in Brunei. There is also Dr. Max Stur, who will provide a comparative study of the Constitutional Court in Hungary and Slovakia when there is a value conflict in democracy. Various topics and interesting discussion from other speakers need to be followed, carefully considered, including important issues from the decision of the Indonesian Constitutional Court, which will be presented by some academics from Indonesia. Maybe Prof. Bayu, also Yance and Rosa, and my colleagues Andy will deliver this issue. In my opinion, studying various constitutional law practices with a comparative study approach as the objective of this international symposium will broaden our perspective in finding the best solution when similar problems or conflict occur. Therefore, I hope the speaker, respondents, and also the participants of this international symposium can have active and critical discussion so that they can explore the various concepts and ideas conveyed in the next 2 days. As explained in the introduction session by Faiz and Ibu Ayu, selected papers from this symposium will be published in the Constitutional Review, which is a journal of international repute published by the Indonesian Constitutional Court. The article published in this Constitutional Review journal usually serve as references and scholarly reading for the constitutional justices. It is like our mind reading. We always read the Constitutional Law Review. For these reasons, if there are suggestions, inputs, or criticisms from the participants in this international symposium on the draft articles that have been submitted, please refine them so that when published they will have greater scientific weight and quality. Ladies and gentlemen, as I conclude my keynote speech, I hope this international symposium can run smoothly and the discussion that develop can bring benefits to the advancement of learning. Furthermore, I hope the discussion and papers presented can be a reference for all of us in finding the best way to deal with various conflicts that might occur in each country. Thank you very much.
Thank you so much, His Excellency Professor Saldi Isra. Ladies and gentlemen, before we start our first session, I would like to invite His Excellency Professor Saldi Isra and His Excellency Dr. Suhartoyo to have a photo session with all distinguished chairs, speakers, and also respondents. Please kindly go to the stage that has been prepared, the front stage, and our committee will lead for the photo session. for chairs and also distinguished speakers can follow the Honorable Constitutional Court Justice, His Excellency Professor Saldi Isra and Dr. Suhartoyo. And I would like to remind all participants, online participants, to always keep the update information that is available on the chat room, including the invitation, the attendance form. Okay, for some speakers, you may step on the stage behind His Excellency. Yeah. Okay, and we invite all speakers, respondents, and also chairs to open your mask in 1 minute. And I guess I will follow the photo session. Okay, everybody's ready. Smile. Count on 3, 2, smile. Once more. Count on 3, 2, capture. Okay, thank you so much. That's the end of our photo sessions. We would like to thank you for His Excellency Professor Saldi Isra and His Excellency Dr. Suhartoyo, the Honorable Justice of the Constitutional Court of the Republic of Indonesia, for your information that the Honorable Constitutional Justice would attend another meeting. So we will start our first sessions in the next several minutes. Okay. All speakers, chairs, and also respondents, please kindly return to your seat. Allow me to remind you that today we will have our first session that will be led by our chair, Dr. Muhammad Ali Safaat, the Dean of Brawijaya University, Indonesia. And I also would like to remind all speakers University of Brawijaya. I'm sorry. And I also would like to inform and remind to all speakers and also chairs who haven't submitted your ticket, your flight ticket. Later, you can submit your ticket and boarding pass to our committee, Rosmalina or Selma Adana. But it's okay, you can submit later after the first sessions. Okay, without further ado, we would like to start our first session. Please welcome Dr. Muhammad Ali Safaat. The time is yours.
Constitutional Court of the Republic of Indonesia. Scotland. Professor Woo Young-ri, Seoul National University School of Law, the Republic of Korea. Profesor Bayu Dwi Anggono, Faculty of Law, University of Jember, Indonesia. Dr. Anne Black, T.C. Burns School of Law, University of Queensland, Australia. Dr. Michael Fahyas, The Hague University of Applied Sciences, the Netherlands. Dr. Miriam Cohen, University of Montreal, Canada. Andi Omara, PhD, Gajah Mada University School of Law, Yogyakarta, Indonesia. Muhammad Mofa Al-Afghani, PhD, Ibnu Khaldun Bogor University, Indonesia. Max Stewart, PhD, OP Jindal Global University, Jindal Global Law School, India. Tholt Thabo, PhD, Karoli Gaspar University of the Reformed Church, Hungary. Dr. Yance Arizona, Gajah Mada University School of Law, Yogyakarta, Indonesia. Dr. Rosa Ristawati, Faculty of Law, Erlangga University, Indonesia. Dr. Radian Salman, Faculty of Law, Erlangga University, Surabaya, Indonesia. Sarah Michelle Vincent Wright, LLD, Faculty of Law of Université de Montréal, Canada. Umi Iliana, Independent Researcher, Advocate, Indonesia. Rian Adivira Prabowo, Faculty of Law, University of Jember, Indonesia. Nando Yusel Mardika, Faculty of Law, University of Jember, Indonesia.
Okay, Assalamualaikum warahmatullahi wabarakatuh. Very good afternoon for all distinguished speaker and participant online and offline of the 5th Indonesian Constitutional Court International Symposium, Constitutional Court and Conflict Resolution. And it's a great honor for me to be invited by the committee as chair of this symposium. So I have the opportunity to listen, learn, and discuss concerning the current research, current condition of the Constitutional Court in all of the world. And in the next 2 hours, we will discuss the paper that will be presented by 3 speakers. And just a brief remind that the speaker have 20 minutes to present the paper, and then the respondent will deliver the response to respondent 10 minutes, and then question and answer 10 minutes. So we will give first to the participant offline in this room, and also we will, after that, we will give the opportunity to the participant online in the Zoom meeting. But for the participant in the Zoom, you might raise your hand or directly write the question down in the chat box. And for the first session, we have the speaker, Honorable Professor Engin Yildirim, and then the respondent, Professor Woo Yuri from Seoul National University School of Law, Korea, and Pak Lutfi Widagdo Ediono from the Constitutional Court of Indonesia. And Professor Engin Yildirim will deliver the paper. The theme is the Turkish Constitutional Court in the State of Emergency Period 2060 to 2080. I think the paper will describe and analyze the pattern of the decision of the Constitutional Court, the Turkey Constitutional Court, both in abstract review and also individual complaint. That's have the different pattern. So without further ado, please, Professor Engin Yildirim, time is yours within 20 minutes.
Thank you very much, Mr. Chairperson. I'll be talking about the Turkish Constitutional Court's judicial approach during the time of state of emergency, which was declared as a result of a failed coup attempt by the followers of a religious group within the Turkish armed forces. Constitutional courts in recent years have become active players in protecting human rights and freedoms in many parts of the world. But this is happening in a very challenging political and economic circumstances. Democracy seems to be in decline. Populism in all shades seems to be on the rise. And academicians, politicians, lawyers, they are fond of talking about democratic backsliding in many parts of the world, including well-established democracies. When there are exceptional conditions, such as the imposition of a martial law or a state of emergency as a result of an external or internal threat to the constitutional order, rights and freedoms are inevitably restricted to address threats to the constitutional system. Under such circumstances, courts are expected to protect human rights. But, and this is a big but, they are also expected to not to imperil efficiency of the emergency measures dealing with the serious threats against the state. In some jurisdictions, there are explicit bans regarding judicial review of emergency decrees, and Turkey is one of these countries. Even when there are no procedural or substantial constitutional hurdles during the emergency periods, courts tend to avoid examining issues related to emergency powers and measures on the merits, using legal tools such as the political question doctrine, or maintain these issues are non-justiciable. According to some researchers, even if they examine a legal challenge against the emergency powers, peak courts tend to decide the case in favor of the government. Let me give some brief information about the background of the state of emergency. There was a failed coup attempt, and in the immediate aftermath of it, a state of emergency was declared. The state of emergency lasted for about 2 years. In the initial period of the state of emergency, there were mass detentions, arrests, dismissal of public officials, confiscation of property, dissolution of associations and trade unions, closure of media outlets, revocation of passports. So these were the most important emergency measures taken under the state of emergency. During the 2-year period, the government issued 36 emergency decrees. Initially, state of emergency was declared for a period of 3 months, but it was extended 7 times. And when the state of emergency was declared, the government immediately notified the Council of Europe and the United Nations about derogating from certain human rights obligations under international law. In this case, European Convention on Human Rights and International Convention on Civil and Political Rights. A stumbling block from the text of the Constitution, 1982 Constitution, arises. There is an explicit ban on judicial scrutiny of emergency decrees by the Constitutional Court. Under normal times, the court has the power to review the constitutionality of decrees. Article 148 stipulates that no action can be brought before the Constitutional Court alleging unconstitutionality as to the form or substance of decrees having the force of law issued during a state of emergency, martial law, or in time of war. There was a challenge from the main opposition party. The party claimed that the court should examine emergency decrees despite the explicit ban on the Constitution. Article 6 of the Constitution also declares that no person or organ shall exercise any state authority that doesn't emanate from the Constitution. In this challenge, the court held unanimously that it didn't have the jurisdiction to review the decree laws issued under the state of emergency, adopting a textualist interpretation of the Constitution. In its examination, the court looked at objectives of the constituent power and related legislative documents and reached the above conclusion. There were some applications to the European Court of Human Rights claiming that there wasn't any effective remedy since they couldn't file a lawsuit against measures issued in the form of emergency decrees. They argued that the Constitutional Court, doesn't have the competence to review emergency measures, therefore shouldn't be regarded as a remedy. That should be exhausted before lodging an application to the European Court. The Strasbourg Court issued an inadmissibility ruling claiming that individual applications to the Turkish Constitutional Court provides an effective remedy. While the court refused to examine emergency decrees, but it received taking individual applications. The Turkish Constitutional Court has the authority to conclude individual applications since 2012. So even in the state of emergency period, the court took individual applications and concluded some of them. Of course, these measures created a great number of applications. On average, the court was receiving 20,000 individual applications in a year before the state of emergency. But during the state of emergency period, this figure increased to more than 80,000. So there were 80,000 individual applications related to measures. People were claiming that measures were infringing their constitutional rights. In ordinary times, the court reviews individual applications based on Article 13 of the Constitution. This is the proportionality principle of the Constitution. According to this article, the court examines an individual application in terms of its legality, requirements of democratic order of society, and the principle of proportionality. In extraordinary times, it is required to use Article 15 not Article 13. Article 15 authorizes substantial restrictions on human rights and freedoms, but any restriction of a right mustn't interfere with non-derogable absolute rights and liberties, violate obligations under international law, and must be required by the exigencies of the situation. This article actually is very similar to the European Convention's Article 15. It also deals with emergencies. During the state of emergency, when the court reviews an individual application, it first applies the standards of normal periods as laid out in Article 13. If it finds a violation of a constitutional right, it then moves on to examining whether this infringement could be justified within the framework of an emergency regime under Article 15. Let me give an example from an individual application. In a ruling, the court held that failure of bringing applicants detained in a coup investigation before a judge for a period of 8 months and 18 days after the first trial would lead to a violation according to ordinary standards under Article 13. But this measure was necessary and proportionate under Article 15 due to complexity of coup investigations and workload of courts and public prosecutors. In another application lodged by two famous journalists who had been arrested following the coup attempt on suspicion of having connections with coup plotters, the applicants alleged that their initial and continued pre-trial detention was a breach of their right to liberty and security and of their right to freedom of expression and freedom of press. The court held that reasons for pre-trial detention were based solely on newspaper articles which didn't convincingly constitute evidence that the applicants were implicated in the failed coup attempt. The court found that the applicant's prosecution and following detention didn't correspond to any pressing social need in a democratic society and was therefore not proportionate, even under the conditions of the state of emergency. The court went through a challenging time during the state of emergency period. But the question is, did it legitimate the executive overreach by rejecting the review of emergency decrees, which results from an explicit constitutional ban? Some academicians and lawyers heavily criticized the court for not reviewing emergency decrees because some of them were really against the Constitution. Some of them weren't related to emergency decrees. The executive, the government, actually abused its powers granted to it by the emergency law. But on the other hand, there is an explicit constitutional ban. When we were dealing with this case in our court, we discussed this matter a lot. And unfortunately, we came to the conclusion that we couldn't do anything as long as that constitutional ban exists in the constitutional text. Otherwise, we would face a risk of a slippery slope. Courts are also bound by the Constitution. Courts don't write constitutions. They interpret it, okay, but they don't write constitutions. They are not allowed to make constitution. It's the constituent power. It's people or whatever. They are the ones who make a constitution. Substitution of the constitutional provisions with personal views of judges, however well intended, as I said before, may carry the risk of a slippery slope. It would create an unruly judicial activism in the name of protecting human rights. I know this is a very difficult position. The courts need to strike a balance. They need to walk a tightrope in a very delicate way. But when the country is faced with a serious threat, and I emphasize that was a real serious threat, because a group, religious group, wanted to overthrow the legitimate government. And they used violence to achieve their ends. More than, as I said before, more than 250 people were killed. So, of course, probably there were some miscarriages of justice. I couldn't deny it. And now, but when the state of emergency was lifted 3 years ago, there is a special commission was set up to address some miscarriages of justice, to compensate people's rights. And many people were again reinstated in the public government. I mean, there were about 80,000 public officials. They were dismissed from the government. It is called, the leader of this religious group is Gülen. It's called de-Gülenization of the government, de-Gülenization of public office. It was a harsh, there were harsh measures, but they were in a way necessary to protect the constitutional order. Otherwise, the country at the moment would be run by a religious group, a fundamentalist group. And probably I would be in a prison. Thank you very much for your attention.
Thank you, Professor. Now more than just 15 minutes. I think it's very helpful for me and also for the committee, because after this first session, we will have the opening ceremony by the President of the Republic of Indonesia. And thank you for the explanation concerning the experiences of the Turkey Constitutional Court in balancing the national interest, constitutional order, and then to protect very basic of human rights. And I will give time to the Professor Woo Young Ri to give the response, suggestion for the paper of the Professor Engim Yildirim. And please, no more than 5 minutes.
Good afternoon. My name is Woo Young Ri, and I'm a member of the faculty of Seoul National University School of Law in South Korea. Thank you for this opportunity for me to comment on Professor Yildirim's presentation this afternoon, through which I have learned a lot, and I appreciate it. Professor Yildirim's presentation this afternoon challenges all of us here as students and practitioners of constitutional law and constitutional adjudication to think hard of this important question of far-reaching ramifications on each nation's separation of power structure and rights protection institutional design as to I made it a threefold question, but the main question goes whether and how to constitutionalize state of emergency power, particularly in terms of first, legislative branch's function in subsequently curtailing or countering or even nullifying it through, for example, approval. And secondly, whether executive branch's exercise of emergency power should be and to which extent subject to judicial or adjudicative review. And third, in a larger context of constitutionalizing even transitional justice. Specific constitution may design emergency power this way, as in the case of South Korea, or not, as in the case of Turkey with its Article 6, as we learned through Professor Yildirim's presentation this afternoon. Then the question is, what should be the function and applicable standard of review on the part of the Constitutional Court when it does review the constitutionality of the measures taken as emergency measures by the executive branch, typically in the form of executive orders and decrees, and not just in the state of emergency situation as in the attempted coup or other military nature. We have seen it through our experience during the COVID period, the pandemic period, as to our right to privacy information, including location information, and then the right to assemble for religious purposes and whatnot. So then even more importantly, for the purpose of this session's theme, we face the question of which specific mechanism of constitutional adjudication will be more suitable, at least for this role of the Constitutional Court, particularly for individual rights protection, with the possibility of applying coordinated and established global standard for human rights. I completely agree with Professor Yildirim with his stance that rights protection is most urgent in state of emergency situation, and the possibility of applying established global standard for rights protection is most needed in state emergency situation as well. This is why we have to take this point seriously in reassessing the system design we have in our own jurisdiction as to whether we have a specific mechanism as a type of constitutional adjudication for direct application for individual redress, and how to fine-tune the design as to justiciability, standing, and the standard of review, particularly in relationship between the constitutional adjudication and the judicial court's litigation for this purpose, if the specific jurisdiction does have two separate institutions. This is even more so as many communities become growingly polarized beyond diversification, and in these settings, normal political processes operated by a legislative branch might come short of the anticipated function of resolving differences and or conflicts by way of legislation to begin with, and this might even exacerbate demerits of judicialization of politics, even causing politicization of the judiciary. So, if I may conclude, I would like to underscore that the most significant and resonating finding and suggestion of Professor Yildirim for us this afternoon, in my view, is that the type of review enabling applicants with a relatively easy and direct access to the Constitutional Court for redress based upon concrete ex post facto review is more likely to be effective in protecting individual rights and thus fundamental constitutional rights as a whole, particularly in state of emergency situations, compared to more traditional or conventional methods of constitutional adjudication to be typically initiated by government institutions. So, if I may ask a question to conclude my remarks, let's say, if I am allowed to ask Professor Yildirim to please share more with us his view as to the distinction between concrete and abstract review in terms of the type of adjudication for the purpose of allowing direct application for constitutional review and the state of emergency against executive measures. And let me invite back later Professor Yildirim for his view on this. And just out of pure curiosity, I'm also curious as to whether there has been any attempt or effort to revise or amend Turkey constitution on this, in this regard, to allow the Constitutional Court to review the constitutionality as a constitutional law measure. So let me conclude my response with this, and thank you for the wonderful opportunity to be part of this session and this wonderful conference. Thank you very much.
Thank you, Professor Ri. And next, I give the opportunity to Pak Lutfi Widagdo Ediono.
Thank you, Chairman, Professor Ali Safat. My name is Lutfi Widagdo Ediono. I'm what we call now is Judicial Assistant of the Courts, and I'm also a Managing Editor of the Constitutional Review Journal. And first of all, I would like to say congratulate to Professor Yildirim for your paper. This is your third time joining Iccis, and we are very grateful that some judges are willing to send article and paper to us, because it's very important and crucial for academics and researchers to get insight from inside the building. And with the theme and issues that you raise is very important, especially about how the court and the Turkish Constitutional Court, especially Anayasa Mahkemesi, in 2016 and 2019. And I'm also curious with what happened in Turkish Constitutional Court at that time, because if I'm not mistaken, after the coup happens in June 2016, some constitutional judges arrested, similar with some judge reporter at that time. So some academics said that there is a threat for the Constitutional Court in Turkey for their independence and impartiality. And could you please to explain a little bit about it? And I'm curious also with your statements on your paper that during emergency the court have a limited and circumscribed power in reviewing the acts and activities in the executive power. In my opinions, because this is what we want to get the lesson learned from the Turkey experience, what do you think? Is it better if the court still have that authority in reviewing constitutionality of law even during the state of emergency? Thank you so much.
Thank you, Lutfi. And from the presentation and also response from Professor Ri, for Indonesian people, it's very interesting because Indonesian constitutional court do not have the authority in individual application or constitutional complaint. So if the Constitutional Court of Indonesia have not authority to review the degree of the emergency situation, so what's the mechanism for the Indonesian people when in Indonesia declare in emergency situation? So it's very interesting. And next, I will give the opportunity for the participant, and I remind to the participant online in Zoom, if you have the question, you can write down in the chat box or raise hand sign. And first, I give the opportunity for the participant in this room, maybe 2 participants. Okay, we have 2, Professor Ann Black and Pak Yance. Please, Associate Professor Ann Black, time is yours, maybe 3 minutes, around 3 minutes. Okay.
Thank you. I found that fascinating because I'm looking at a country that's been in a state of emergency for 60 years when I give my paper tomorrow. So my question is simply, what is your mechanism for amending the Constitution? And would that be something that you think would...
Could you close the microphone? Yeah.
Sorry. I seemed loud to myself. My question is, what is your mechanism for amending the Constitution? And I think, Professor, you also touched on that. I mean, would this ban, would the problem be solved if it went to a referendum or if there was an amendment to the Constitution?
Of course.
Sorry, Professor, could you please we will give the time to you.
Later. Okay, okay.
Okay, Pak Yance.
Thank you. I just would like to follow up and also to emphasize the question from Lutfi, because we hear from news and also reading some book that during the state of emergency that there were 2 Turkish Constitutional Court judges get arrested by the ruling government. Why did they get arrested, and what happened to them afterwards? And who are replaced their positions? And the question is whether this arrest also influenced the independence of the judiciary as well, the performance as well. And because you are also serving for the Constitutional Court Justice for more than around 12 years, is there any difference of the performance of the Constitutional Court before the state of emergency and the current position? Because you know that when the government is become more dominant, it's become too risky for the court as well to put a strength position with the government position. Thank you.
Thank you, Pak Yance. And we have one participant, online participant, that raised hand. Pak Raditya, maybe we give the opportunity first. Pak Raditya Veda, please. Sorry, you. Okay.
Okay, sorry. Okay, thank you very much. My name Raditya Veda. I'm from University of Merdeka Malang. I want question to Mr. Professor Engin Yildirim. In the world we see there are so many violations of human rights that human rights are very poorly implemented in fulfilling human rights. And the question, how the Constitution can be targeted at fulfilling human rights. Thank you very much, Mr. Muhammad Ali Safat.
Thank you. Thank you. And I think the last question from Professor Roy Andrew, please.
Thank you very much. First, this topic is so close to the very core of constitutional law. Where are the limits of...
Could you close to the microphone, please?
Is it not on? Oh.
Because we are...
Apologies.
Okay.
So what I was saying for the audience is this is so close to the core of constitutional law, whereas the line between politics and law is two different systems. But more fascinating, and I think this is really what you're raising, is can constitutions save a constitutional process? Or does that become a self-referential problem that undoes a constitution? And I think there's something so marvelous and philosophical in your paper. And I don't know, give us a little bit more on that. It was so fantastically fascinating. I just wanted more. Thank you.
Thank you, Professor Roy. And I give time for Professor Engin Yildirim to respond or answer the question of the respondent and also from the participant, please.
In my personal view, actually it is the court's view. In this decision, the court said that in a democracy, all laws, including emergency decrees, should be reviewed. We wrote this in our decision, but unfortunately, our hands are tied because there is an explicit ban. It says you cannot even examine or open the box to look inside it. If you open the box, you may probably find some unconstitutional arrangements. Then you can invalidate them. But the Constitution says you cannot open it. Of course, there are many tools available to courts if they want to pass over them, if they want to go around them. But as I said before, this would create different problems. In the past, in the early 80s, in the early 19s, at that time, there was a martial law in certain parts of the country where the government was fighting against separatist terrorists. And at that time, again, a legal challenge was raised against these emergency decrees under the martial law, and the court then decided to examine it. And it actually annulled some of the provisions. But again, at that time, it was heavily criticized because people said that the court overextended its power. It used a power not recognized, not granted by the constitutional text. Of course, the Constitution doesn't mean it's just a written text. It's more than the written text. But in the name of protecting human rights, and this is my personal opinion, you may disagree with it, you cannot ignore or overlook an explicit written materials. This seems to be a debate in the United States between the originalists and the others. But actually, I am not very fond of a textualist interpretation of the Constitution. I think Constitution is an evolving body, it's a living Constitution. It should be interpreted in the light of these developments. And its main aim is it should be to protect human rights and freedoms recognized in the Constitution. But under some exceptional cases, the constituent power says, you give me some more freedom so that I can deal with this threat efficiently. If we look at what happened in the I am not an expert about what happened in the United States after 9/11, or in France, or during the 70s in West Germany, in West Germany, during the Baader-Meinhof extreme left-wing terror times. As far as I know, German Constitutional Court, which is very famous for its right protective activities, they decided in favor of the government when the case was about Baader-Meinhof terrorists. So when you have a when you face a serious threat, and I mean, of course, I must admit, this is open to abuse. Any government can claim this or that threat is very serious. But 9/11 was a serious threat, Baader-Meinhof was a serious threat, and the coup attempt in the Turkish case was a very serious attempt. That's why the European Court of Human Rights, until recently, they adopted a kind of hands-off approach. Because, you know, Turkey is one of the countries that receives most violation decisions by the European Court of Human Rights. Unfortunately, we have a European record after Russia, but of course Russia was now dismissed from the court. So I think we will probably become the top country, unfortunately. When I say this, I really feel ashamed, because unfortunately, some parts of the government, the Turkish government, they are inclined to abuse their powers, whether in normal time or whether in state of emergency times. So when we recognize that there is a serious threat that should be done, that should be dealt with, we expect the legislative, the executive, to act in accordance with the Constitution. But they interpret this as a kind of free rein. They can do whatever they want. And the constitutional text is a serious obstacle in the protection of constitutional rights. Hopefully, now there are new talks about writing a new constitution, because we have an upcoming presidential and general elections next year. And the president, 2 or 3 days ago, said that they will make a new constitution protecting human rights a lot. Whether it will be realized, time will tell us. I can't say anything about that. And actually, when I was talking, I forgot to add, these emergency degrees are supposed to become law, and they are supposed to turn into ordinary statutes, so that they can be reviewed by the government. Although there isn't any time span which says that emergency degrees should become statutes, it's expected that the legislative should should turn these emergency degrees into law in just 2 or 3 months' time. But unfortunately, in some cases, they did it in some cases, but in other cases, unfortunately, they turned these emergency degrees into ordinary laws in 1 year later, 1.5 years later, and it created problems. So in order to prevent the executive's misuse of emergency powers, I think the Constitution should allow the Constitutional Court to review its emergency degrees. But this doesn't mean that when we review these decrees, we shouldn't hamper efficiency of the government measures. As I said in my presentation, we need to strike a balance, and probably you will agree with me, this is not an easy thing. And you feel yourself under pressure, not from the government, from the public opinion. People are inclined to trade security for liberty. This is the reality of today, whether we like it or not. So we live in a difficult time in terms of protecting liberties, and unfortunately, the future doesn't seem bode well. So these are my views about the questions. Okay.
Okay, thank you, Professor Engin Yildirim, and ladies and gentlemen, we have finished the first part of the session 1 of this afternoon. And give applause for speaker, Professor Engin Yildirim, and also respondent, Professor Wu Yongri and Pak Lutfi Widakdo Ediono. Thank you very much. And for the second speaker, we have Dr. Michael Fagias from the Hague University of Applied Science, the Netherlands. Will present the paper Amnesty and Peace Building, a dialogue of the depth between constitutional and international court. I think it's also, we discussed concerning balancing between actually post-conflict situation that usually use amnesty as one of the instruments to make reconciliation between the parties. But on the other hand, it's for the human rights activists, it's a kind of impunity for the perpetrator of the human rights. So I invited Dr. Michael Fagias to the stage, and the respondents, Dr. Anne Black from University of Queensland, Australia, please, and Anantia Ayudevita Sari from Constitutional Court of Indonesia. Okay, thank you, and without further ado, I have time for Mike. For Mike, Dr. Michael Fagias to give the presentation within 20 minutes. Please, time is yours.
Hello. Hello, everybody. I hope you can hear me and everything works well. Excellent. So, good afternoon, everybody. I'm not going to take 20 minutes. This is going to be much less painful and much easier. So, with this paper, I'm trying to address a topic that is quite classical from the perspective of international human rights law and the perspective of international criminal law. Maybe it's not something that constitutional law or comparative law lawyers are very much familiar with. In any event, I decided to give it a go since the theme of this conference is constitutional courts and the resolution of conflicts. And sometimes there are resolution of conflicts that are adopted by legislative or executive powers, but then the constitutional courts are asked to review that resolution and its compatibility with human rights norms. So here, we are not necessarily asking from a constitutional court to act as the conciliator, because the executive or the legislative branch of government adopting an amnesty legislation purports to act as a conciliator. Here, we have usually a situation where a victim of torture, a victim of enforced disappearance, or the family of a victim of enforced disappearance during a civil war. After the conclusion of the civil war, there's usually a peace treaty under the auspices or with the guarantees of international actors or not. And in that peace treaty or subsequent to that peace treaty, there's the adoption of an amnesty legislation. And the amnesty legislation provides for a complete amnesty or partial amnesty or conditional amnesty for infractions, crimes, violations that were committed during or in connection with the situation of internal armed conflict, in connection with the situation of civil war. There are numerous international scholars who have written on this topic, but before I begin, I would like to mention one name, and that name is Fazlun Budi, who was a participant in one of our first trainings that we organized for the Constitutional Court of Indonesia, and he was a source of inspiration for me to write this paper. and our thoughts are with his family after his passing. So in Indonesia as well, you had the adoption of amnesty legislation following the 2015 Aceh and the Helsinki Accords that were concluded under the auspices of the Finnish government and then President Ahtisaari, sometimes also known as the Ahtisaari Agreements. In practically every country in the world where you have had an armed conflict, an internal armed conflict, you have had some sort of an amnesty. And it has been rather recently the movement that developed after the 1990s, particularly in the countries of the Americas. We call them also Latin America or Central America, where following the Pinochet regime, the Fujimori regime, amnesties were instituted by those regimes in order to make sure that after they step down, no one will prosecute them. And in many different dictatorships in the Corn of America, in the Corn of America, there were subsequent petitions brought by victims of significant human rights violations before the national courts, asking for prosecutions to begin. Because usually when the petitioners approached a national prosecutor, the national prosecutor refused. So they wanted actually the Constitutional Court to kind of force a national prosecutor to investigate and, if evidence was present, to prosecute and eventually obtain a conviction for the human rights abuses that happened during the period of the Civil War, during the period of unrest, during the period of a dictatorship. It happened many times that the Constitutional Court judges refused. They said, nope, we are going to uphold the amnesty. And then the petitioners in those jurisdictions had access to regional human rights courts. And through these regional human rights courts, they obtained decisions that actually said that the award of amnesties for certain types of human rights violations are incompatible with the state obligations under the regional human rights instruments applicable in that jurisdiction. In the Americas, we're talking about the American Convention of Human Rights, and the instrument that took the lead was the Inter-American Commission in the beginning of human rights, and later on the Inter-American Court of Human Rights. So the result of this process was that eventually, even though in national jurisdictions, many people would think that the buck stops with the Constitutional Court judge, actually the buck did not stop there. The buck went all the way over to a regional human rights institution, which then gave to the petitioners a judgment to ask them from a Constitutional Court to reopen, revisit its original decision, if possible, and to actually have an investigation happening. The abridged version of my paper numbers 33 pages. Originally it was a 60. I'm not going to bring you through the pain of reading through 33 pages. Instead, what I am going to do is tell you that in broad lines, what happened was that the courts said that amnesties are not compatible with state obligations under human rights treaties, particularly two state obligations: the access to justice, the victim's right of access to justice, known in the American system also the right of judicial guarantees sometimes, and the victim's right to truth. Because when there is a case of enforced disappearances is the case particularly in South America when somebody would be abducted from their house, put in military police custody, then placed on a plane, flying in 50,000 meters, opening up the door and throwing the person out of the airplane. There would be nothing left after this process, and that would be a situation of enforced disappearance. And then the question would be, for that petitioner, we need to know what happened, and that's enough for us, but we need to know. We cannot live our lives waiting for that door to open, and maybe one day somebody will walk through. Amnesties would also cover cases of enforced disappearances, and this gave rise to a very strong discussion, particularly after the decisions of the Inter-American Court of Human Rights that were followed suit by the Secretary General of the United Nations, by the Extraordinary Chambers of the Court of Cambodia, by the Special Court of Sierra Leone, who all agreed that amnesties are not compatible for certain serious human rights violations. This gave rise to the dominant view, I call it the dominant view anyway, that is espoused today by the Office of the High Commissioner of Human Rights, that amnesties are not compatible with state obligation to prosecute. And therefore, So this is the normative line. The consequence is that, in the words of the Inter-American Court in Almonacid Arellano versus Chile, constitutional judges have a duty to conduct something known as the conventionality control. That means that when they have an amnesty case before them, they have to make sure that their decision is consistent with the previous jurisprudence of the Inter-American Court of Human Rights interpreting the American Convention. Now, this position, which has been adopted by numerous international actors, is not, however, in my mind, the position of the law de lege lata. It can be the law de lege ferenda. For those of you who are not very clear on the Latin aspect, it's not the law as it is now, but it is the law as it can eventually maybe develop one day in the future. And by way of example, even though my paper is about constitutional law judges, constitutional court judges, I draw the examples of two international, let's call them international courts, the International Criminal Court and the European Court of Human Rights. In the European Court of Human Rights, there were many judgments by sections of the court. For those of you who are not familiar with that, a section of the European Court of Human Rights is not the full, the plenary and bank. It's not the 17-member Grand Chamber. It's 5 judges who are going to decide the case. And in those sections, there were quite a few decisions which said that, yes, amnesties are not compatible with serious human rights violations. There's a duty to investigate. This happened, this was kind of lurking in the background, if you will, all the way up to the Grand Chamber decision in Margus versus Croatia. And Margus versus Croatia was a seminal decision issued by the Grand Chamber of the European Court of Human Rights, where the Grand Chamber said, and you will excuse me if I actually read this paragraph, because sometimes you read a thing, judges read a thing, and you feel that you're reading different things. So the court actually said, in the present case, the applicant was granted amnesty for acts which amounted to grave breaches of fundamental human rights, such as intentional killing and inflicting grave bodily injury on a child. The county court's decision reasoning referred to the applicant's merits as a military officer. And then the court said, the Grand Chamber, a growing tendency in international law is to see such amnesties as unacceptable because they are incompatible with the unanimously recognized obligation of states to prosecute and punish grave breaches of fundamental human rights. Even if it were to be accepted that amnesties are possible where there are some particular circumstances, such as a reconciliation process and or a form of compensation to the victims, the amnesty granted to the applicant in the instant case would still not be applicable. Where does it say here that amnesties are not compatible with human rights obligations? It says that there is a growing tendency. It doesn't say that they are not applicable. There were numerous of separate and dissenting opinions on this, many of which said that the next step in the evolution of the law would be the outright prohibition or compatibility. This paragraph that I just quoted to you was used in the case of Makuchian and Minazian versus Azerbaijan and Hungary, which is the case of a military officer by Armenia, 2 military officers of Armenia that went on a NATO training school in Hungary. And a few rooms down the military barracks where they were actually staying was a military officer of Azerbaijan. And one night, the Azerbaijani military officer RS took an axe, went to the room of the Armenian military officers, chopped the head of one of the Armenian officers off, and attacked the other with the intent to kill him. The Hungarian authorities arrested, prosecuted, punished, put in jail the individual, but at some point there was an agreement concerning the transfer of prisoners after conviction, the European Convention, and both Hungary and Azerbaijan were parties to it, and Azerbaijan succeeded in obtaining the transfer of the convicted prisoner from Hungary to Azerbaijan. The moment he arrived in Azerbaijan, he stepped off the plane, the president was there to greet him on national TV. He was given pardon, he was given 8 years delayed salaries, and he was given a flat by the government to stay in Baku, and at the same time he received a military promotion. So in the context of that case, the Chamber said, the 4th section of the court after Margus, so relying on that dictum that I just read to you, it said, pardons and amnesties are primarily matters of member states' domestic law, and are in principle not contrary to international law, save when relating to acts amounting to grave breaches of fundamental human rights. This was quoted again, the Makuchian Orbiter, in a case of EG versus Moldova, which was the case of a sexual assault of a girl that went out in Chisinau, and she was sexually assaulted by 3 persons, for one of whom was recognized the possibility of, it's not exactly an amnesty, but the court refers to it as an amnesty because that person was within a certain age limit, one of the 3 perpetrators was within the age limit, and within that age limit, when the sentence threatened was below certain years, then he could avoid prosecution. One of the courts hearing the case said, no, he enjoys amnesty. He fled. Then the appeals chamber reversed, but by the time he had fled and he was nowhere to be found. In the context of that case, the same Makuchian dictum, save when they involve international crimes, was again repeated. To my mind, this is not what the Grand Chamber said in Margus. The Grand Chamber in Margus did not say that amnesties are incompatible. It says there's a growing tendency. We don't know where that tendency is at the moment. So until somebody proves to me, at least, who's speaking to you now today, that this has crystallized into a rule of customary law, we are still at the wave or developmental stage. 6 minutes. The ICC appeals chamber had a disagreement with the ICC pretrial chamber in the Gaddafi case. Saif al-Gaddafi, one of the sons of Muammar Gaddafi, former head of Libya, was arrested by Libyan authorities, still held in Libya by a paramilitary group. It's not exactly clear to what extent the Libyan authorities can control that group. That's a different story. But at some point, ICC proceedings, International Criminal Court proceedings, started against him for serious international crimes and his participation in that. There was an amnesty legislation that was passed at some point. So there was a question brought before the ICC pretrial chamber, can that amnesty preclude his prosecution? The pretrial chamber in the beginning said, excuse me, not really, but in the end, after 8 pages of reasoning, it said that under international law, they're incompatible. This went to the appeals chamber, and the appeals chamber said, international law is still in the developmental stage on the question of acceptability of amnesties. The pretrial chamber appears to have accepted that rather than determining that this question was settled, it found a strong growing universal tendency that grave and systematic human rights violations are not subject to amnesties or pardons. In these circumstances, the appeals chamber will not dwell on the matter further. 5 minutes, and I conclude why I consider that the growing tendency is the way to describe it. There are 3 clusters of criticisms that I consider the most important among the many criticisms that are directed against the incompatibility thesis, the thesis that amnesties are incompatible with human rights obligations. The first relates to democratic legitimacy. Usually amnesties are not only adopted by the legislative branch, but they are also subjected subsequently to referendum. They are also presented as part of a general peace agreement. So a famous author whose name escapes me right now, but I will find it, mentioned in 2000, around that time, that the Inter-American Court had Gavron. She mentioned that the Inter-American Court, when she said that the amnesties were inapplicable in El Salvador, in Uruguay, and in Argentina, bypassed completely the fact that the Uruguayan amnesty was adopted by legislation approved by referendum. The Argentine laws were passed by democratic government in the wake of an investigative commission with high-level prosecutions. In El Salvador, there were similar democratic processes. So in these circumstances, the main criticism against human rights institutions is that they are acting, they have created a super right of victims' access to justice, and that they are acting as aristocratic organs guilty of human rights absolutism. One author says that this human rights absolutism is a manifestation of a mistrust by human rights institutions to democratic process. Because he says that after the Second World War, there was an emergence of an obsession with rights, because after the rise of Hitler and Mussolini in power through a democratic process, there was an international shift in emphasis from how the law is made, and if the law is made democratically, to actually thinking about the individual human rights as the standard that needs to be observed, regardless of the democratic process followed in a country. The second line of criticism goes back to the reasoning followed in the Inter-American Court, where one of the former presidents of the Inter-American Court said that we have to avoid absolute predeterminations. We have to try and weigh things, as opposed to predetermining if it has the A word, it is a bad thing and it should be stricken out, declared null and void ab initio. And the third school of thought comes from criminologists, people that we usually associate with science that is closer to religion than mathematics. And criminologists say, are critical of courts because they say that they take a very legalistic approach. They speak for victims, but they haven't asked the victims. So they suggest that victims might be perfectly happy just to know where are the remains, what happened to the loved ones, having a truth-telling process, and figuring out some sort of a compensation or reparation regime, individual or collective, a monument process and the like. So I find particularly some of these criticisms very interesting. And well, my position is that the incompatibility thesis is not there yet. Louise Malinder, one of the foremost authors on this, found that number of states, even after the Secretary General's famous statement of incompatibility, have still adopted amnesty legislations. And even though it might not be the best example, please recall that the UN Security Council adopted the Minsk agreements, Minsk I and Minsk II, and there is a paragraph in the Minsk agreements that provides for amnesties. And that is in a resolution adopted by the UN Security Council, if memory serves, in 2015. So, on that note, I'm going to stop. I'm very sorry that I took so much time, and thank you for your patience. I'm looking forward to your questions.
Thank you, Mike. Conclude with a very brief criticism against the thesis that amnesty incompatible with the human rights protection. Now I give time to Dr. Anne Blacks to respond or make suggestion for the presentation of the Michael Fagias. Please, time is yours within 5 minutes.
Thank you. I've had the pleasure of reading the entire paper and enjoyed hearing the summary of it also now, because at first glance, when you look at these sorts of competing rights, you think it's a very provocative argument that you're going to raise. But as I proceeded through the paper and reinforced again today, I'm rather convinced by the comprehensive thesis that you present. Now, I hasten to add, I am not an international law lawyer, so a bit of a failing there, I guess. But I do bring my comparative lens to it, and I do share concerns about blanket international law norms always overriding determinations of a democratically elected government, especially if what the elected government is doing is better reflecting a more culturally appropriate way to heal after a brutal conflict or after an egregious human rights violation, whether by a group or by individuals. If within that context the answer lies in an amnesty, then I think that should have considerable weight. Now, as a comparativist, I know each nation adopts very different ways for managing conflict, as we'd expect. And this is going to be informed by reflecting the deep-seated cultural values which will differ in all of our contexts. But here we are in Indonesia. This is a Pancasila nation, endorses religious practices, not just Islam, but also the other great religions, including Christianity. And putting on that hat, I sort of think of Muslim and Christian beliefs in vengeance being the right of God, being the right of Allah. And that also comes with the forgiving, compassionate, and merciful nature of the divine. And so I can see why this concept of amnesty and pardon and truth-telling and reconciliation would resonate in a country such as Indonesia or in others with similar domestic contexts. So essentially, to me it seems that if it's a more culturally appropriate way to heal and to draw a line in the sand so that the nation can move forward and individuals can move forward, then I'm convinced by your argument.
Okay, thank you, Dr. Ann Black. That's the response to the Michael Fagias concerning the cultural values and the religious influence to the society. And we give time to Anantia Ayu Devitasari to deliver the response. Please, time is yours.
Thank you, Dr. Ali Safat. First of all, I would like to express my gratitude for being invited to be a respondent for my dear friend and colleague, Dr. Michael Fagias. I hope you have a terrific day here, as well as for the other speakers and audience. In the peace and justice debates, the debate of amnesty law sometimes turns into ethical confrontation between the government or peacemaker and the human rights advocate. Amnesties are often treated as a tool for making credible commitment for a larger peace offers. Governments argue that amnesties are in the best interest of local populations desperate for order and safety in a post-war and post-conflict environment. If amnesties assist in ending destructions and preserves life, they are worth the cost they bring to justice. On the other hand, human rights defenders are concerned that amnesties are ethically incorrect because they interfere with international law obligation to prosecute crimes and violate the victim's access to justice. Leaders also can use the law to hinder themselves from future criminal prosecution. For human rights advocates and organizations, forgiving the war crime is an act of mercy that helps the country, but forgiving them for right abuses is tragedy. I couldn't agree more with you, Michael, regarding the judge's role continues to consist on striking a balance between competing interests, values, and rights. My question for you, do amnesty really works in terms of giving sustainable peace in post-war and post-conflict environment? If so, in what term? Second, even the amnesty law did not prohibit it under international law, but in the 1999 law accord for Sierra Leone, the UN officially articulated the position that it could not condone amnesty for war crimes, crimes against humanity, or genocide. Given that the Rome Statute for the International Criminal Court obligates states to prosecute those who commit such acts. Moreover, on what ground and prerequisites did the Constitutional Court should review the amnesty law related to the war crimes and crimes against humanity? Because there is no simple approach for states and victims to heal the wounds for such a violent conflicts. Thank you again, Michael, for shining some lights on this insightful topic that you brought into discussion.
Thank you, Ayu. This already gives some response and I think 3 or 4 questions. Now we wait for the respondent. And now we give opportunity to the participant in here to raise comment or question for the speaker. Okay, first, okay, we have 3 here, Professor Christie, and then, I cannot see, Muhammad Mova, and Professor Bertus de Viller. Please first, Professor Christie to
Thank you. I really enjoyed this paper and this presentation and the comments of the respondents because this is a dilemma that I face in my own work too. The relationship between rights-based advocates and the realist views that say that, especially after a long period of time, say in Cambodia, where it's been so many decades after the fall of the Khmer Rouge and before the tribunal was composed and carried out its responsibilities, and of course it just ended last week, that compelling victims to testify only destabilizes society further in a way that they have worked so hard to recover from. And I struggle with this, peace versus justice conundrum myself, and raise exactly the question, Professor, that you raised, which is why aren't the victims consulted more often? Is this really only a question that the state and human rights advocates should weigh in on? What if the victims want to know more than anything where their children are buried or where the bones of their spouses are buried, and they may even accept that knowledge in lieu of reparations? Sometimes just getting the truth out is more conducive to bringing peace than a government interest in prosecution. That's my question, I guess. And I don't know that.
Okay,
I don't know there's an answer. I think maybe we all struggle with that.
Thank you, Professor Christie. And we move to Pak Nova.
Thank you for the very interesting presentation. In certain traditional or indigenous communities, for example, if there is tribal warfare or someone get killed, they merely present an offering, make peace by, for example, slaughtering an animal or a pig, and then they make peace. So my question to you is, what if we look at the other way around? Is the duty to prosecute through the legalistic means is somewhat imposing a certain values of justice and somewhat probably against legal pluralism, the spirit of legal pluralism? That's my question. Thank you.
Thank you. We move to Professor Bertus.
Chair, it was a very interesting paper and comments. I just want to comment, not as much ask a question on the last point that was made. Does amnesty work? And to me, there are two principles in this regard. The one is that amnesty doesn't mean one approves of the atrocity. Amnesty has a different function. But the second is that perpetrators must know there's a consequence. And these are two principles that are at war with one another. They are not simple to reconcile. In South Africa, there was this question about amnesty, and Bishop Desmond Tutu played a leading role to say that amnesty would heal the wounds. And he made of amnesty a deeply spiritual event. In fact, he was then the chairman of the Truth and Reconciliation Commission, and he started the functioning of the commission with communion in the Christian tradition. So that's how, in a certain sense, he raised the level of it to a spiritual event. But up to today, that has still been criticized. There are some people that say, well, South Africa would not have ended apartheid had it not been for amnesty, and some say the perpetrators got off too lightly. It's an ongoing debate. I think the point I would make is that without amnesty, there's sometimes no end to a war. There's no end to apartheid. If there had not been amnesty, apartheid wouldn't have gone. There would have been a protracted war with much more atrocities than, in a certain sense, you try to stop it and start afresh. Can I just use three examples? The one is that of South Africa after apartheid. But the other is that people often don't know. At the turn of the century, the British invade South Africa and invaded the two Boer republics and set up concentration camps, and many thousands of Boers died. And when the Queen recently passed away, it was still an unresolved issue in South Africa. Why did the Queen not apologize? Why did she not apologize? So that thing remained unsettled of just having some form of reconciliation. So my question perhaps is, are there degrees of atrocities where one could say some could be dealt with by way of amnesty and some not? Does one reach a certain point where the atrocities in Cambodia just can't be dealt with by an amnesty because it's just too brutal? But then on the other hand, some atrocities such as apartheid, which was more of a political action, could be dealt with, but there were also people killed. And does one then say, well, it's a numbers game. The more that are killed, the less you can have amnesty, and the less that are killed, where does one go to then? So I'm just saying, at the end of the day, amnesty is the art of the possible. If you don't stop it, you may not stop the conflict.
Okay, thank you. And for the last question, we have one online participant. Please, Ibu Alvina Rianti. Ibu Alvina. Sorry, you still in the mute mode. Okay.
Okay. Good afternoon, Mr. Paul. I'm Alvina from University of Belfast, Indonesia. Okay. It's very important about amnesty. Even if I'm not agreeing, I'm very respectful for your opinion. Okay. I just want to ask one question. So, your opinion, which is some case that worth it to get that amnesty? For the other constituent, remind that you agree if amnesty may have to applicate or some case. Thank you.
Okay, thank you. And I think it's very, we have much comment and enrichment to the presentation of the mics, the experience in Cambodia and in South Africa and the other. So at the end, I will give the time for mics to respond and answer the question from the respondent and also from the participant. Please, Mike.
Very, very quickly. First of all, thank you all very much for your insightful comments. I will start with Professor Black, who is correct in saying that in circumstances where amnesties did work, they were connected with, let's say, the deeper substrata of the cultural psyche of a certain nation. And I will turn to the comment made by Professor De Villiers. This was actually what I had written in response to your question, that the most successful story is the South Africa story. And the main commentators believe that if it hadn't been for later Archbishop Tutu, this would not have worked. It's very likely that that human being made such an important difference because he tapped into deeply rooted notions of forgiveness, community, understanding, local traditions that maybe to an outsider I cannot even begin to understand. I cannot even begin to get them. So, but please understand one thing in international law. International courts are very formal. They don't seem to have a lot of time for, and I know that this doesn't sound very kosher to say, but they don't seem to have a lot of time for traditional mechanisms, for reconciliation, for adjudication, and the like. I wish it was different, but I don't think it is. Then there was a question by Ayu about do amnesty really works to reconcile imposed conflict and the duty to prosecute. So on what grounds can a constitutional court review? First of all, the position of the constitutional court judge in these circumstances is essentially cleaning up the dirty work of a legislative or the executive. And I think that at some point, constitutional courts should say basta to the parliament and to the executive, and to kind of tell them that they have to do their job right, because otherwise they cannot do it for them. So what does that mean? It means that there's a lot of value before you adopt an amnesty legislation to talk to the constitutional court judges and tell them for what? What would be compatible with our constitution, instead of leaving them aside and then waiting for things to explode, and then you say, it's not my fault, the constitutional court judges have to clean up my mess. So I think that there is some value in that train of thought. Do amnesties really work to reconcile imposed conflict? Yes, but not alone. So Louise Malinder has written a book. She has the Belfast Principles for Accountability. And in her work as a criminologist in particular, she has explained that amnesties can be one tool in a toolbox, but trying to use just that tool, it's not very likely that it will work on its own. You need to have other measures, other steps. You need to have truth-telling. You need to have truth and reconciliation commissions that actually work. Because sometimes, and I think one of the colleagues is going to make a presentation, sometimes a Truth and Reconciliation Commission can be used as something to hide behind, so that you can avoid more formal processes. We'll see. It depends, and the reason why, and if I can be very honest with Professor Black and all the comparativists here, is that every country is so different in the way that they approach amnesties that simply undergoing through the history of one country, not compare with other countries, but go through the amnesties adopted by a country in different moments in its own history is a very, very difficult proposition, to put it mildly. For victims are not consulted, according to Professor Warren. Yes, victims are not consulted because victims are very difficult to consult. In the ICC, they currently have a victim application process where in every situation there are thousands of victims. So can you imagine the questionnaires? 63% of the victims, of the thousands of victims, say they want, 37% they say they don't want. It is very difficult in mass atrocity, systemic situations, to get individual opinion. I understand the practicality of it, but at the same time, doing justice in the name of someone should resonate a little bit with the person in whose name you deliver justice. It's called legitimacy, I think. There has to be some sort of legitimacy in that process. Professor Mova, duty to prosecute and imposition of values of justice. I will close here by reverting to a book by David Kennedy and Marty Koskiniemi, which is called The Dark Sides of Virtue, where they actually say that sometimes human rights courts fall into exactly the trap that you just mentioned. And they said specifically that human rights jurisprudence appears predicated on allegedly universally accepted norms only to camouflage choices particular to an institution. From this perspective, a court may attempt to present itself to domestic audiences as a neutral and emancipatory voice of universally accepted truths in order to bolster the acceptance of its exercise in interventionist judicial activism. I'm going to leave you with these thoughts. There are a lot more that can be said about it. I have spent considerable time thinking and writing about it. This will be my second piece because I'm looking particularly into the function of the judge, the balancing of rights and all that. But I will save that for another time because I think that there is an actual president of a republic waiting for us. So thank you all very, very much. And thank you to the audience as well.
Okay, thank you. And give applause for the speaker and also respondent. Thank you very much. The last part for this session, we have Pak Andi Omara, PhD, speaker, and then we have respondent, Professor Miriam Cohen, and Ibu Rima Yuwana Yustikaningrum. Pak Andi Omara will present the paper, The Unintended Consequence of the Indonesian Constitutional Court ruling on the Truth and Reconciliation Commission law. It's actually correlated to the amnesty. It's also because the law on Truth and Reconciliation Commission has been nullified by the Constitutional Court based on one of the argumentation. I think it's because the compensation, it's depend on the amnesty, whether the amnesty is granted or not. So, Pak Andi Omara, time is yours. You have 20 minutes to deliver your presentation.
Thank you very much, Mr. Chairman. Ladies and gentlemen, I would like to present my paper, and the paper that I will present is concerning about the approach of the court in dealing with the Truth and Reconciliation Commission's law. And when we talk about the unintended consequences of the Indonesian Constitutional Court ruling on the Truth and Reconciliation Commission. Thank you very much.
This is what I wait for. So this is my the title of my paper, and what I'm trying to look at is actually the court approach. I'm not dealing about the mechanism of truth and reconciliation itself, but I want to look at how the court approach in reviewing the Truth and Reconciliation Commission's law. Next, please. And this is the outline of my presentations. First, I will look at the purpose of the study, literature review, and then KKR law is actually the Truth and Reconciliation Commissions. In Bahasa Indonesia, we call it Komisi Kebenaran dan Rekonsiliasi. Look at the background contents as well as the purposes, and then we move to the actual judicial review of the law, look at the background, the petitioner's identity, and the petitions itself. And then we move to the court approach in reviewing the constitutional, the Truth and Reconciliation Commission's law, and finally I will draw conclusions. Next, please. And when I read this paper, I found at least 3 important literature reviews, looking at what actually the role of the Indonesian Constitutional Court in dealing with the conflict resolution mechanism. Marcus Michener and then Jorn Dressel's work, as well as in comparative views. I also look at Rios Figueira's books on the Constitutional Court as a mediator between civilian as well as military in pursuing order and national security. The frame that I'm using is actually from Catherine S. Young typology, where the court and the implementing agency is actually have unique relations. How actually court have several strategy with regard to the decisions and how the decisions can be effectively implemented to the implementing agency. In this case is the legislature or the lawmakers. And when we see there are 3 important labels of court. The first is the Supremacist Court, meaning that court actually control without putting the legislature positions to fix the law. And then the detached law is actually where the court more differential in the way that the court try to restrain itself and putting that this actually the power of the legislature to decide. And finally, the far below is actually engaged court. In these models, we can see that the court effectively engage with the legislature based on the court decisions. And this is the typology that I'm trying to mirror with the court decisions in Indonesia since its establishment in 2003 and its development. When we look at the first technique, for example, the court often declare the law null and void, but in some cases, it also invalidates the law in its entirety. And when I look at the Young typology, I would say that it's fall under the peremptory or under the Supremacist Court. And when we look at the second type of the court technique, we can see that the declarations of incompatibility is actually a more engaged court rather than the Supremacist Court. And then there are some other techniques that the court often use other than the one stated in the Constitutional Court law, like the judicial order directed to the lawmaker or conditional decisions, where the court put conditions in order to maintain the law constitutional, otherwise it's considered unconstitutional if such condition is not fulfilled. And then we move to the Truth and Reconciliation Commissions. What actually the background why the government or the lawmakers has actually established the Truth and Reconciliation Commission law. Basically, we have gross violations of human rights back to 1960 or 1965, and then after that. And we don't have yet the established human rights court in that period of time. And we have the specific human rights court, I think in 2000 or 2006. And the question is how to resolve the problem before the establishment of the human rights court. And one of the proposal in that how to deal with gross violations of human rights in the past is by using the Truth and Reconciliation Commissions. And based on the law, we can see that the Truth and Reconciliation Commission is an independent body. The aim is to resolve gross violations of human rights in the past, prior to the establishment of the Human Rights Court, and using non-litigation process. And when you look at the purpose of these new bodies, the Truth and Reconciliation Commissions, we can see it's not only reveal the gross violations of human rights, but it's also followed by the reconciliations. The more detailed political duty or function is to respect the gross violations of human rights, reveal what happened in the past, and also have a significant effort to reveal the gross violations of human rights. And then we have at least 4 important duties of the TRC, starting from receiving complaints, investigating gross violations of human rights, advising President in granting the amnesty, and then providing recommendations to the President. And move on to the next slide, we can see there are even more authorities of the TRC, starting from carrying out investigations, seeking information, issuing documents, and then coordinating with relevant institutions, summoning the individual relevant to the case, deciding granting compensations, restitutions, as well as the rehabilitations. And finally, it's also have the authority to reject the request of compensation, restitutions, and rehabilitations if the case has been submitted to Human Rights Court. And then we move to the actual judicial review of the law. And when we look at the petitions, we can see that this petition is submitted by 6 NGOs concerning human rights protections and 2 individuals. And they believe that some article of the Truth and Reconciliation Commission law, specifically Article 1, Subarticles 9, Article 27, and Article 44, potentially violate the right of the victim from discriminations, and it also violating in obtaining justice. In short, the petitioners believe that these articles violate the Constitution, specifically Article 27, Section 1, 28D, and 28I of the 1945 Constitutions. And then when we look at the detail, like Article 27, there is what we call, like Pak Ali Safaat says, the compensations and rehabilitations may be granted if the amnesty application is granted. And that become questions on whether it is create equality before the law or non-discriminations, as well as right to compensations. And it also put the questions whether this also create equal positions against the perpetrator. And then when we look at Article 44 of the law, we can also see that the article says that human rights violations has been resolved by the TRC, cannot be brought to the court. That also another important questions that raised by the petitioners. And again, when we look at the other article, they also say that amnesty, pardon granted by the president to the perpetrator of the gross violations of human rights, should take into account the considerations of the DPR. So in short, when we look at those 3 or 4 different articles, the petitioner says that they violate the constitutions. It creates uncertainty, it creates or neglect the right of the victim, and it also potentially creates legal uncertainty. Now we're moving to the court reasoning. The court reasoning is basically, I would say that the court reasoning agree, or the court agree with the petitioner's arguments. The 3 or 4 different articles provided by the petitioners all agreed by the court. The only potential problem for me is because the court do not only address those articles. The court go beyond the articles in their legal reasonings, and when they draw conclusion, they're not only looking at this 3 or 4 article requested by the petitioners. And that actually heavily influence the decisions of the court. The court not only consider these 3 different articles, but also other articles, and these other articles, based on the court reasonings, actually become the important points of the law. And if the law miss this article, the law will not work as promised. That's why when we read the court decisions, the court decide that instead of invalidating those articles, the court choose to invalidate all or the entirety of the law, meaning that the law on the Truth and Reconciliation Commissions is actually invalidated in its entirety. So my analysis in this case is actually, first, I would say that normally and normatively, the court will only look at the article that is requested by the petitioners to review by the court. But in this case, the court go beyond that articles and looking at other articles. That would be the first facts that I want to look at. And then the second, the court also in the decisions go beyond what already stated by the Constitutional Court laws, because there is no declarations of the court that says that the court can invalidate the law in its entirety. Normally, the court just granted or rejected or inadmissibility based on the petitioners or the article that requested by the petitioners. But in this case, the court go beyond that, the article of the law. And then the third analysis that I draw, the conclusion that I draw, when we look at the Young analysis, I may say that the court in here act as supremacist court. It means that the court actually handle everything without providing opportunity to the lawmakers to fix the law, because the law invalidated in its entirety. So in my opinion, when I look at the ruling of the court and the future on how we deal with gross violations of human rights in the past, I would say that the court already developed many approaches in declaring the law. And then in this particular case, I would say that in my opinion, it would be better if the court did not invalidate the law in its entirety, but instead the court provide conditional decisions. Why it is so? Because it provides the opportunity for the lawmaker to fix the law. And hopefully the court already puts some guidance or interpretations, and if the lawmaker do not comply with the court interpretations, it probably can be further reviewed by the court. At least by having these declarations, we still have the Truth and Reconciliation Commission's law. Because so far, after the invalidations of the law, we don't have any mechanisms in place to deal with such violations. And only recently, I think in September 2022, we just got the presidential decree forming a committee to address the human rights violations in the past. If, in my opinion, the court provide a more engaged models where the court provide what we call as conditional decisions, hopefully the lawmaker will fix the law and we have more rich and comprehensive mechanism to deal with past human rights violations. And by having what we call engaged court, it provides an opportunity for the lawmakers to fix the provisions, and this avoid what we call a legal vacuum. So we have a law in place to fix the problem. And by applying the engaged court, I also said that the court may act as a mediator, because by having these functions, the court can mediate what actually the constitutional feature that the court actually require and what actually the lawmaker should do to make them constitutional. And I think with that, I will end my presentation. Thank you.
Thank you, Pak Andi Omara. At the beginning of the Reformation era in Indonesia, of course, we deal about the past gross violation of human rights, and that at the time in Indonesia, the concept of transitional justice is very familiar for the people, and one of the manifestation of the transitional justice is Truth and Reconciliation Commission at the time. But I don't know, maybe right now we lost the momentum concerning the Truth and Reconciliation Commission. But yeah, it's still a very interesting topic because we still have the problem deal with the past gross violation of human rights. Now I give time to Professor Miriam Cohen to respond the paper and presentation of Pak Andi Omara. Please, time is yours.
Thank you very much, Mr. Chair. Let me start thanking Professor Omara for a very interesting paper, which helped us think through how to respond to past human rights violations. and what roles Constitutional Court can play in this process. I found the paper quite enlightening and interesting, and it's a good way to analyze how a truth and reconciliation law can help us understand the process of judicial review in Indonesia and the role of Constitutional Court of Indonesia in resolving conflicts. Your paper also elucidates the important role of the separation between law and politics. In fact, your research question is an interesting one. What is the role of the court in dealing with political cases and in resolving past human rights abuse? One question that inspires me is to what extent the case study that you used can provide a lens through which we understand the role of the Constitutional Court in judicial review cases more broadly. Furthermore, from a theoretical and methodological perspective, you analyzed and adopted the theory of Catherine Young. This was a fascinating prism through which your research question was treated. In this regard, I wonder how this theory assisted in your overall conclusion that the judgment had the unintended consequences. Another illuminating point of your article is the argument that the Truth and Reconciliation Law shifts the paradigm from retributive to restorative justice, and that the impact of the ruling can have in this paradigm shift. I would be delighted to hear more from you on this point. Another interesting aspect of your research is the finding that the court did not close the possibility of resolving past human rights violations through reconciliation. I'd be interested also to hear your view on whether this is the case with the invalidation of the law in its entirety. To finalize my remarks of this fascinating analysis that you provided us today, and that fits within the broader topic that we started discussing earlier in this conference on how we respond to past human rights abuse. It's also interesting to see that you conclude that invalidating the entire law will make the resolution of human rights disputes case remain unsolved. And I would like to hear more from you on the path forward and the role of the Constitutional Court in other cases moving forward. So let me again thank you very much for this fascinating research that you provided us, and I'll give the floor to the next respondent.
Thank you, Professor Miriam Cohen, and I'll give time to Ibu Rima Yuwana to give a response, please.
Thank you, Mr. Chair. And thank you, Bapak Andi Omara, for your enlightening presentation and bringing up KKR law case to this forum so we can discuss it more. Thanks to you, I can read the court decision repeatedly after reading your paper. And in this session, I'm honored to take my chance to ask a question about your writing. Bapak Andi Omara, for what specific reasons do you not elaborate on the court legal reasoning, which explore the court ground in deciding not only the requested statute or any provision of the statute, considering the answer to your question in your paper, which questioning how the court applies a superior approach in reviewing the KKR law, which invalidates the entire law instead of only 4 provisions, are well explained in legal reasoning, page 126. Even the court highlighted Article 45 of South Korea Constitutional Court law, which allow the Constitutional Court to decide not the requested statute or any provision of the statute as a comparison. Also, the court has mentioned case number 1-21-22 of the year 2003 about electricity case to describe its similarity to the KKR law case. I mean, the court highlighted that if it is deemed that the entire provision of the statute are unable to force due to a decision of unconstitutionality of the requested provision. Thank you.
Okay, thank you for the response that's compared with the decision according to the law on electricity. And the court said that the clause is the heart of the law. So if the heart is unconstitutional, so the whole of the law should be unconstitutional. And now we give opportunity for the participant in here. Okay, Mr. Bayu, the other one, Max, and Professor Bertus. I think three for participant. Professor Bayu, please.
Thank you, Chair. Thank you, Professor Andi Omara, for the very interesting presentation. I think Pak Omara bring a dilemma on the Constitutional Court decision on TRC or KKR law. As I read through the paper and listening your presentation, I guess you want to deliver this dilemma. To launch reconciliation through the imperfect 2004 TRC law as stated by Justice Palguna in his dissenting opinion, or to nullify the entire law and to make a new and better one. Mr. Omara then proposing and at the same time questioning why the court did not the conditionally constitutional interpretation to end that legal vacuum. I agree with Mr. Omara, however, there is problem. There are elements of transitional justice which require political approach, including how to TRC shall be designed. The conditionally constitutional, in my opinion, is that the court or constitutional court shall decide the deadline for the legislative to make a new TRC law. That's my opinion.
Okay, thank you, Professor Bayu. And Professor Bertus? Yeah.
Chair, thank you for an excellent paper. Can I just make ask a question and make a comment? The question is the fact that the court ruled on articles that were not pleaded by those making the petitions. Normally that would be an error in law. So if this was a lower court, a higher court would be able to set that decision aside. My question is, were there dissenting judgments? Were there judges who disagreed with that judgment, and did they follow the same line that you presented in your paper? That's my question. But then the point that I would make, amnesty is often offered in an exchange for truth. That's what this act intended, and that's also what happened in South Africa. But there are two aspects that makes that difficult. The one is, what is the truth? Who decides whether somebody has admitted enough? And if they admit a bit but not enough, can they still go to prison? But if they admit everything, they don't go to prison, and who decides that? That was a major issue in South Africa. And the second question is, must both sides admit if they had wrongdoing? For example, in South Africa, the ANC said they fought a just war. And even though they may have killed innocent people, their war was just. And so only those who perpetrated apartheid had to tell the truth. Now, later on, that was also resolved. But there's a question. Do both sides admit their wrongdoing? Or is it only the one that is more guilty than the other one that admits their wrongdoing?
Okay, thank you. And the last for Max.
Thank you very much, Professor Omara. This was a fascinating presentation. And I have a conceptual question more on the models of judicial decision-making that emerge from your analysis, because you refer to this distinction between the legal and the extra-legal model in your paper. And I wonder whether this analysis actually indicates that there is no such thing as a legal model of decision-making where the judges only consider very mechanically, technically, the text of the law, the provisions of the law. And then perhaps whether there are some indications in the judgment that they may have been following some kind of a model of law as integrity by Ronald Dworkin, a legal philosopher, which is sort of in between the legal and the extra-legal, if you will, but questions this possibility of there being just a mechanical kind of decision-making that some of the political scientists you refer to in your work would advance. Thank you very much.
Okay, thank you. And we don't have a question from the online participants, so I will give time to speaker, Pak Andi Omara, to respond or question from the participant and also from the respondent. Please, Pak Andi.
Okay, thank you very much, Mr. Chairman. So, first of all, I would like to thanks to all the respondents as well as the participants who raised questions or comments on these issues. And the first from Professor Cohen regarding, if I'm not mistaken, she's commenting on the elaborations of why the court saying even though the court declaring the law in its entirety unconstitutional, but it doesn't mean the court closed the opportunity for the lawmakers to make the better law. So I think in my point of view, this kind of your law is not good enough, so make it a better law. So in my perspective, it would be better, for example, if the court provides some, not only guidance, but also like Professor Bayu said, some timelines or some what we call deadlines. But probably it's not as important as the guidance itself. We may make the guidance without any timeline, but it would be better if there is a timeline. In this case, the court will, in my opinion, provide directions or suggestions or particular interpretations that perhaps will be the reference of the lawmakers in making the law better in the future. And regarding the human, what we call the resolutions of past human rights violations after the invalidations of the law, I think merely over 16 years after the invalidations of the law, we do not have such mechanism anymore. But only recently, in 2022, the president issued a decree and formed a committee that should address, based on the Human Rights Commission's recommendations to the DPR. It consists of, if I'm not mistaken, 13 or 15 gross violations of human rights prior to the establishment of Human Rights Court. And this team will address these issues. The thing is, the presidential decree itself only valid until the end of this year, and it can be renewed. But for me, it seems that it is very short to reveal this such difficult and complex situations. So I think that's my first comment to Professor Cohen. And then to Ibu Rima, I think you raised a very important what we call analogy when we talk about how the court declared the electricity law also unconstitutional in its entirety. So this is the development of the court decisions, not by looking at the law, the existing law, but by quote unquote importing or adopting or quoting the South Korean constitutional court law. And it's expressly mentions in the decisions that quoting that particular article, the court says that using this particular article of the Constitutional Court of Korea, we will adopt this to decide this present case. So I think in this case, the court, I don't know, is it a legal transplant or So that actually the one that I also wonder why it is the South Korean, why it is the South Korean constitutional court law become the reference of the court. Why not the other court? But many is actually, we reflect, many mirror the constitutional court of South Korea. And then, and also the issue of the heart. So I think this heart terminology become a very important terminology when Chief Justice of, I think, Professor Jim Lee says that if the article is the one whom the most essential of the law, then instead of invalidating that one particular important essential articles, we better to invalidate all the law. But I do not know what actually the heart means, because I think every article matters in the law. And then Professor Bayu, regarding the conditional decisions, I do agree that I think when we provide or when the court declare conditional decisions, it also creates what we call as a constitutional dialogue between the body that decide the case and the body that will implement or will what we call follow up the court decisions. And by having an engaged court, I think it would not only maintain the validity with certain conditions, but it also provide a better way to make a better law. And then we have Professor Fillier. Unfortunately, I do not focus on that practice, but I think when we look at the law, there are some, important terminology like the restitutions, the compensations, and the rehabilitations. But on the other hand, there's also an amnesty. So, but the rehabilitations, restitutions, as well as the compensations is actually conditional if the amnesty is actually granted. So the question you raise, whether it is, in my opinion, it may be reciprocal. So the perpetrator, the allegedly perpetrator, or the victims, they just reveal what actually happened in the past, and then they tell the truth. I don't know, the truth whose versions, but I think there should be a way to then, like what we call a triangulate approach, how we can understand that one subject says something true by looking at other subject, other there is coherency and that kind of, maybe that would be the method. And finally, Professor Max, when we look at from the lens of political science, I often see the legal and extra-legal approach, but I do agree that many cases actually decided not only looking at the legal doctrine or the articles, but it really depends. I mean, sometimes I look at the decisions of the court very focused on what actually the Constitution says. But in other cases, the court, even in my understanding, go not only different from the provisions of the constitutions, but go against the provisions of the constitutions. For example, when the Constitution says that there is a limitations from the Constitutional Court to only review law against the constitutions. But the court now also able to review the government regulations in lieu of law. And the Constitution says that right to life is actually non-derogable rights, meaning that it cannot be derogated in any circumstances. But the court says that it can be limited. So I think by understanding case by case, we know that in certain case, we see that the court very elaborative. Actually, I also inspired by Professor Villiers' articles on how actually the court very detailed in one case. But in other cases, the court is just looking at one or two examples, and the decisions is actually not only valid for today, but also for the future. I think that's all my response. Thank you so much again for all the respondents.
Thank you, Pak Omara. And ladies and gentlemen, distinguished speaker and participant, since the gamelan music has already occupied our room, so we have to end this session. Thank you very much for the discussion that's very fruitful for our knowledge, for our experience concerning the decision and then relation between constitutional court and political condition in specifically concerning conflict resolution. Again, thank you very much, Pak Omara, Professor Cohen, and Rima Yuwana. Thank you very much. And now we end this session, and I will give time to the Master of Ceremony. Thank you, and applause for follow-up.
Thank you so much, the Honorable Chair, for leading the discussion very nicely. Ladies and gentlemen, that's the end of our first sessions of the 5th ICCIS. Well, we apologize for the inconvenience of the sound of gamelan because there is a grand rehearsal for the next event or the next agenda, which is an official opening ceremony of the 5th WCCJ. We have some informations to be announced for all of attendees here, for all speakers and respondents who have been tested PCR yesterday. After the session, should attend Nusa Dua Hall 5 to attend the opening ceremony at the latest time at 6:15 p.m. Before that, after the session, you may enjoy your coffee break. The coffee break has been served on the foyer in front of Nusa Dua Hall 1 and 2. And after the opening ceremony, there will be a gala dinner that will be hosted at Melia Hotel. All speakers and the invited speakers will be transferred there by a shuttle bus. And we have to remind you, ladies and gentlemen, that tomorrow our session will be started at 8 in the morning, 8 a.m. So you have to be ready a little bit earlier than today, probably around 7:15 or 7:30. There will be a shuttle bus that will transfer all of speakers who stay at Ritz-Carlton. Well, I think that's all that we can announce for today. Thank you so much for all of your participations and the great discussions. See you tomorrow in the next sessions of the 5th ICCIS. Wassalamualaikum warahmatullahi wabarakatuh. ladies and gentlemen, for all of you who haven't been tested PCR yesterday, should stay in this room until the opening ceremony ended at around 7 p.m. And kindly reminded for all respondents